working tension.
My Lord, may I first apologise for the delay. A 5-minute journey took an hour and a quarter. We got out and left our taxi. The taxi and the papers were still marooned in the snow, so I do apologise for the
Was it snow or students?
We don't think it was revolting students. We think it was heavy snow.
Right.
Sure. No problem.
Yes, Mr. Clark.
My Lords, we were just looking at the point arising from the special treatment of Irish citizens. And I want to take your Lordships now, if I may, to what the Secretary of State's evidence says about the common travel area, since that's central to his justification and also an understanding of the application of the protocol in our submission. And that is in a witness statement, which is at page 103 of the core bundle, the appendix.
Which appendix?
The first part of the appendix.
Part 1. 103, did you say?
Page 103, yes.
Yes.
This version of the witness statement is undated, but it was signed on the 8th of September 2005, and we get that, if needs be, from the judgment of the administrative court in which it was produced, which I will take your Lordships to in due course. That it was filed in proceedings between British citizens from the Chagos Islands and this respondent concerning the requirement to show actual habitual residence to obtain job seekers' allowance. So it wasn't filed in proceedings that concerned the right to reside test. The reason that it was filed was that the allegation made in those proceedings was that there was discrimination between British citizens from the Chagos Islands and British citizens of Irish origin, a claim which failed before the Administrative Court and the Court of Appeal. And I will take you to those judgments in a moment, but I just want to show you, Lordships, for now, what the witness says about the common travel area, which is at page 111 of the bundle, paragraph 22. Paragraph 22, the witness begins by explaining the United Kingdom, Channel Islands, Isle of Man and Republic of Ireland constitute in geographical terms the British Isles and form in immigration terms the common travel area. My understanding is that the common travel area was brought into being in order to reflect the close geographical proximity of all the territories and islands making up the area. This proximity has given rise to strong historical and family links. There's then a reference to the history of Ireland's membership of the United Kingdom, and at paragraph 23, at the bottom of the page, the existence of the common travel area enables the inhabitants to move freely and regularly from one part of the area to another and back again. Indeed, any attempt to introduce border controls with Ireland would not be likely to be practicable. There's an explanation of that. And then the history of the common travel area, as we see at paragraph 24. Common travel area predates the habitual residence test. The Home Office confirms that the common travel area emerged during the 1920s when special legislative provision for the Isle of Man, the Channel Islands and the Island of Ireland was made for immigration purposes by order. In particular, in 1923, the Irish Free State was established with no immigration controls for people travelling between it and the United Kingdom. There's then a reference to the Second World War, but we pick up 4 lines on negotiations between the two governments finally opened in 1952, and the agreement resulting from those negotiations was embodied in, there's reference to various statutory provisions and finally to the Immigration Act 1971. And then in paragraph 25, the common travel area is based on the principle that once individuals have been granted leave to enter one part of the common travel area, they have freedom to travel around the common travel area and will not normally require leave to enter another part of it, whilst that leave is extant, provided that they do not leave the common travel area. And the significance of that for the purposes of her witness statement was that we can see that in paragraph 26, when the government first proposed introducing the habitual residence test in February 1994, so that was the requirement to be habitually resident. It originally intended to limit access to income-related benefits to people who were habitually resident in the UK only. And then we see in paragraph 27, the Irish government made strong representations to the UK government following an adjournment debate in the Dáil on 8th of February 1994. Irish ministers expressed their concerns about the possible implication of the introduction of the habitual residence test for Irish citizens in the UK and the disturbance this would have on traditional arrangements regarding emigrants from Ireland to the UK. And there's then a reference to some statistics about the number of people who had emigrated from Ireland to the United Kingdom in 1993, which wouldn't appear to be confined to Irish citizens, at least not in the text that we have here. That was 18,500 then, and the number of those returning from the United Kingdom was 32,000. Though at the end of the paragraph it said representations made to the Social Security Advisory Committee suggested that Irish nationals would almost certain to be affected more than any others by the introduction of the proposed test.
How much of the details of this do we really need for present
My
purposes?
Lord, I'll come back to it in a moment for the purposes, because it's the Secretary of State's justification, but for the moment that's sufficient. The reason that I will need to come back to it is that it embodies what the Secretary of State says justifies not only the purpose for which this witness statement was made, namely the requirement of habitual residence, but the new requirement of having a right to reside, and why it is that the right to reside test should also be drawn by reference to the geographical scope of the common travel
Let's
area.
come back to it when the point arises then.
My Lord, yes. Can I just then return to elaborate briefly on the points that I made yesterday about the protocol? The protocol relates to this common travel area. And as we've seen from the evidence, under the common travel area, leave to remain in Ireland gives rise to a right to reside in the United Kingdom for the duration of that leave. It doesn't require an additional grant of leave to enter. So in my submission, the reference to Ireland is superfluous to give effect to those who have leave to remain in Ireland. It's also superfluous for the purpose of those who have a right to reside in the United Kingdom. The essential consequence of the reference to the Republic of Ireland, the right to reside test, is that it means Irish citizens are not excluded at all, regardless of their connections to or activities in the United Kingdom, and regardless of whether they have come from Ireland. Now, in terms of whether or not that benefits rule forms part of the common travel area, the first point that we make about the protocol is that it needs to be construed narrowly, because it is a derogation from the general prohibition on discrimination. And for that, if I could take your lordships to the judgment of the Court of Justice in the case of Anchor, which is at volume 4, divider 44.
It's a fairly familiar principle. It's just one paragraph, is it, we need to look at?
It is, my Lord, yes. Simply 871, paragraph 60.
Yes.
So see paragraph 60 at the bottom of 871, it's clear from the court's case law that as a derogation from the fundamental principle that workers in the community should enjoy freedom of movement and not suffer discrimination, Article 39(4) of the treaty, which is a different provision, but again a derogation, must be construed in such a way as to limit its scope to what is strictly necessary for safeguarding the interests which that provision allows the member states to protect. So we say, by analogy, the protocol must be construed in such a way as to limit its scope to what is strictly necessary for safeguarding the common travel area. Now, whatever might be the position for a requirement of actual habitual residence, we say that a provision which extends, which equiparates the right to reside in Ireland with that of the United Kingdom is not strictly necessary for the functioning of the common travel area. We say that in two respects. Firstly, on a strict reading of the protocol, we say that the rule in Regulation 2.2 does not relate to the movement of persons between the United Kingdom and the Republic of Ireland. Of course, a benefit rule can relate to travel between states, but we say that this rule doesn't. Because
Well, some people will move and some won't.
Some people will move and some won't, but also, as in my submission, the only real effect of the rule is not to privilege Irish citizens coming here to work or study or to live with their family members who have a right to reside. It's to privilege Irish citizens who have no right to reside in the United Kingdom. So it's not about their movement, it's about their continued residence in the United Kingdom at a time when they have no right to reside. I should emphasise we don't seek to take that benefit away from them. We simply say the Latvians should have it as well. The second point is that it's not part of an arrangement between the United Kingdom government and that of the Republic of Ireland. There's no reciprocality in the arrangement, and we can see that from the relevant Irish law. If I could just ask your lordships to go there, it's in volume 1 of the authorities at tab 28. Do we have... Now, the provision that the Secretary of State relies upon is section 246 of the Irish Social Welfare Consolidation Act 2005. And that's on the second page of the extract. We see that it says, for the purpose of each provision of this Act specified in subsection 3, it shall be presumed, until the contrary is shown, that a person is not habitually resident in the state at the date of the making of the application concerned, unless the person has been present in the state or any other part of the common travel area for a continuous period of 2 years ending on that date. Now, the first point about this then is that the requirement of Irish benefit law is habitual residence in the state. And if need be, we can show your lordship the text of the sections that are mentioned at 2463 to make that good, but it's clear from the terms of 2461 that that's so. So under Irish law, the requirement is not habitual residence in the common travel area, it is habitual residence in the state. So there is no reciprocality. What 2461 does is simply give rise to a presumption that a person is not habitually resident in the state unless they have been present in the state or any other part of the common travel area. But there's nothing to show that a person who has been living in the United Kingdom for 2 years and then goes to Ireland would therefore be accepted as being habitually resident in the state, because it's simply the case that a person who hadn't been living in the United Kingdom would be presumed not to be habitually resident in the state. So there's not an irrebuttable, it's not a deeming provision that treats habitual residents in the state of Ireland.
Well, it could be construed that way. Do we know how it's being construed?
Well, I don't know how it's been construed, and there's no evidence that it's been construed in that way. But in my submission, it's quite different from the British provision, which treats as equivalent habitual residence in Ireland with that in the United Kingdom, and a deeming provision which relates to a presumption against habitual residence in the state, where that's the primary condition. There is no other evidence of any agreement between the United Kingdom which extends to the provision of benefits, between the United Kingdom and Ireland, which extends to the provision of benefits or which requires this. And there is no evidence to show that this provision was introduced as a reciprocal measure in respect of the provision that your lordships are concerned with. And the last point that I wanted to make under the protocol is that Article 3.1 of Regulation 1408/71 does not affect, that's the language of the protocol, does not affect the common travel area. Application of Article 3.1 simply requires that the same treatment that is given to Irish citizens by Regulation 2.2 is given to Latvian citizens. That doesn't have any effect on the common travel area. It doesn't make any difference to the operation of the common travel area, and it takes nothing away from Irish citizens. Now, the two remaining points that I want to deal with on the Irish point are, first, whether or not the discrimination is justified, and second, whether, if it is not, the reference to Ireland can be severed, as the Secretary of State says it can be. We say, first of all, that the discrimination is direct, and so cannot be justified for the reasons that have already been made about discrimination between Latvian and British citizens. We say, secondly, that the aim of the measure was expressly to discriminate in favour of Irish citizens, and therefore is not a permissible aim, and we take that from the respondent's case. I could just ask your lordships to look there. Paragraph 69E of the respondent's case.
Sorry, the paragraph numbers?
I'm so sorry, it's
69?
Sorry, 69,
Yes.
at page 34. It's at letter E of page 34 of the core bundle. And there the Secretary of State says the purpose of the inclusion of those words in these provisions was to extend more favourable treatment to Irish nationals. Now, the Secretary of State has referred to the justification that was advanced and accepted in the Couronne case. And if I could just ask your Lordships to go to the Court of Appeal's judgment in Couronne, which is in Volume 2 of the Authorities at Divider 36. I've outlined the essential facts to your Lordship. I just want to take your Lordships to the reasoning on justification, which is at page 2786, paragraph 69. And there, this Lord Justice Wall, and on this point, the other judges agreed with him. The principal justification in relation to British citizens of Irish origin is, of course, that the common travel area is a political construct built upon the long-standing relationship between the United Kingdom and what is now the Republic of Ireland. And then, just moving down to 2 lines below E, it is, I think, and it's sufficient for me to say that in my judgment, the decision taken in 1994 to extend the habitual residence rule to British citizens living in the Republic of Ireland, a decision sanctioned by Parliament, and pausing there, that's because the regulation was not disapproved under the negative procedure, plainly constitutes justification for the difference in treatment between British citizens, such as the claimants, who are not habitually resident in the common travel area, and British citizens who are. Well, the justification that's required here is quite different. It's not for discrimination between 2 classes of British citizens habitually resident in the British Isles. It's discrimination between, on the one hand, Latvian citizens, and on the other hand, Irish citizens, including those who are not habitually resident in, who weren't resident in Ireland at all. In my submission, the special treatment of that class is not justified by the existence of the common travel area. This is not a rule that relates to persons who were exercising a right to reside in Ireland. As I've sought to show, it's a rule that privileges, for practical purposes, people who possess Irish citizenship, regardless of their former residence or movement. So if we're right on that, and subject to severance, we say that because the discrimination in favour of Irish nationals is either direct or anyway unjustified, it follows that to treat the appellant less favourably than an Irish national is precluded by Article 3.1 of Regulation 1408/71. But we also make the point that this contradicts the aim, which is said to justify the discrimination in favour of British citizens, namely the aim of protecting the British Exchequer from claims by non-economically active EU citizens, other than British citizens, to the benefit in question. If that were truly the aim, then there would be no rationale for extending it to all Irish citizens by virtue of their Irish nationality.
Well, I just simply don't understand that. Why can't you have countervailing aims? You've got a countervailing aim with regard to the Irish because of the historic links. Doesn't mean that it cancels out all the primary aim. Well, there it is. I don't want to spend time on it.
Well, my Lord, if the justification were that there was special treatment of Irish citizens because they are citizens of a country with which we have special links, then that would be a different target and we would have addressed it in a different way. And that sort of idea was defended below on the basis that we could treat the nationals of other countries in a favoured way. But that's not the justification that is advanced. The justification that is advanced is that it's about free movement of anybody between Ireland and the United Kingdom. But what, in fact, I've sought to show is that the only people who really benefit from it are Irish citizens. So there's a mismatch between the justification and the actual effect of the provision. But I accept that that a measure can seek to pursue 2 aims. But what I say seriously undermines the supposed principal aim is the willingness of the government simply to extend the favour of the exception to people simply on the grounds of their nationality and not on the grounds of any connection to the United Kingdom. The last point is the severance point. We set out in a little detail in the case why we say that severance isn't an appropriate mechanism under European Union law where a regulation is concerned. And in the respondent's case, that's contested. And the respondents say, I won't take your lordship to it, but for your lordship's notes at paragraph 78 of their case, that if we are right, regulation 2.2 has been enacted in an excess of power, and they adopt a conventional ultra vires approach. And we say that's wrong as an application of European Union law. Where a provision of a European Union regulation is engaged, it's the regulation that must be applied rather than the national rule. But that does not alter or require to be amended the domestic legislation. It does not render the domestic legislation ultra vires or incompatible. It's simply a superior rule of law that takes over where it applies.
So this is paragraph 177 of your case, is
Yes,
it?
my
So
lord.
you're saying that the article doesn't empower the court, doesn't enable us to amend the regulation.
It doesn't require or enable you. No. You simply look at the superior rule of European Union law. And if I could just take your lordships quickly to Factor Tame, which is at volume 3, tab 41. And in particular to the passage from the speech of Lord Bridge at page 140, paragraph letter B. And here Lord Bridge is dealing with the Merchant Shipping Registration Official Fishing Vessels Regulations 1988 and the Merchant Shipping Act 1988. And in relation to that, he says at B, by virtue of Section 2.4 of the Act of 1972, which is the European Communities Act, Part 2 of the Act of 1988 is to be construed and take effect subject to directly enforceable community rights. And those rights are, by Section 2.1 of the Act of 1972, to be recognised and available in law and enforced, allowed and followed accordingly. This has precisely the same effect as if a section were incorporated in Part 2 of the Act of 1988, which in terms enacted that the provisions with respect to registration of British fishing vessels were to be without prejudice to the directly enforceable community rights of nationals of any member state of the EEC. Thus, it is common ground that insofar as the applicants succeed before the ECJ in obtaining a ruling in support of the community rights which they claim, those rights will prevail over the restrictions imposed on registration of British fishing vessels by Part 2 of the Act of 1988. So my submission, it is as if the State Pension Credit Act had written into it a term which said, in the operation of the regulations made under this Act or in the operation of the provisions of this Act, that shall be without prejudice to the rights of community nationals under Regulation 1408/71, for example.
Well, the way it's put by the respondent in the case at paragraph 78 is fairly blunt. Mr. Lewis says he simply doesn't understand this, and I'm having difficulty in understanding it too. Why can't we sever a provision in domestic law which is incompatible with community law?
Well, my lord, because, for the reasons that I sought to explain, because a regulation of community law does not require domestic law to be altered, does not affect the operation of domestic law as far as persons who are not within the scope of community law are concerned.
Well, it may not require it, but why can't we do it?
Why does the regulation empower the Supreme Court to strike down a provision of domestic law, even as regards persons who fall outside the scope of community law? Well, that would be to exceed the powers that the European Community Act gives the court and place you in the role of the domestic legislator, making law for people who are not within the scope of European community law. Can I just show you, Lordships, the case of Gingy, which is at volume 2, tab 31. So actually, before we leave it, I mean, the analogy would be in Factor Tame if persons who had no community rights under community law had also come to the House of Lords and said, we would like you to strike down the Merchant Shipping Act, because giving the Spanish vessels directly effective European community law won't help us. We'd like you to strike down the whole of the or these provisions of the Merchant Shipping Act, so that we, Swiss fishermen, or Russian fishermen can also benefit from the provision. And we say that if under community law that provision is bad, you should simply strike down the measure. And the answer would clearly have been, but you have no rights under community law to come here. This doesn't affect persons who fall outside the scope of community law. Can I just show your lordships a case on that, as I said, Gingy, which is at volume 2, tab 31. And this was an appeal from a refusal of income support on the grounds that the appellant was not habitually resident in the United Kingdom. But as we can see from the headnote, the appellant was a British citizen coming to the UK from Cyprus. This was before Cyprus had joined the community. And she had no connection with community law. But what she argued was that the community law definition of habitual residence should apply equally to her. And that was resisted by the Secretary of State on the grounds that European community law having no application to her, it made no difference to the domestic law provisions. You see that in the judgment of Lord Justice Buxton at 593, paragraph 10. So Ms Gingy had argued, as I say, that her case should be analysed under the European community law meaning of the regulation, not the national law meaning. Ms Gingy's argument fails for two interrelated reasons. It does not sufficiently respect the distinction between the scope of the domestic and of the community legal orders, and it depends for its logical force upon an approach that categorises the court's task in terms of determining the meaning of particular words used in legislation, as opposed to determining the factual situations to which that legislation is intended to apply. I've already mentioned the well-accepted principle that community law applies only to cases falling within the community legal order. Community law requires a member state, when faced with such a case, to apply to it the conclusions of community, not of domestic law. How in administrative or structural terms that is achieved is a matter for the national legal order, but the community legal order requires no more than that. In respect of cases not falling within the community legal order, it has nothing to say. This is strikingly illustrated by a case shown to us by Mr Ward for the Secretary of State, with reference to the European Court judgment in Imperial Chemical Industries. British tax legislation made consortium relief available only to companies whose subsidiaries were located in the national territory. The Court of Justice held that the rule, when applied in the cases of subsidiaries established in other member states, was inconsistent with community principles of freedom of establishment. The Court was, however, also asked whether that meant that the legislation must also be disapplied or interpreted so as to conform with community law in cases of subsidiaries having their seats in third countries. And the Court replied in paragraphs 32 and 34 of its judgment, it must be emphasised that the difference of treatment applied according to whether or not the business of the holding company belonging to the consortium consists wholly or mainly in holding shares in subsidiaries having their seat in non-member countries lies outside the scope of community law. Accordingly, when deciding an issue concerning a situation which lies outside the scope of community law, the National Court is not required under community law either to interpret its legislation in a way conforming with community law or to disapply that legislation. Now, in my submission, your Lordship's jurisdiction on this appeal to apply community law derives ultimately from the European Communities Act. And by making the European Communities Act, Parliament did not authorise the courts of the United Kingdom to strike down domestic legislation in cases falling outside community law. Now, if your Lordships were to strike down the reference to, as the Secretary of State suggests, or asks, in fact, if we reach this stage of the argument, if your Lordships were to strike down the reference to the Republic of Ireland in Regulation 2, what your Lordships will be doing is imposing an additional burden on Irish citizens who fall outside the scope of community law. You'll also be imposing an additional burden on persons coming here from the United Kingdom, from Ireland, who fall outside the scope of community law. In my submission, that goes beyond the jurisdiction that this court has. This court is required to do justice under community law to the appellant. That does not extend to the court depriving other persons of the benefits that they currently enjoy under domestic law.
May it depend how the matter is worded?
No, it depends upon the practical
Mr. Lewis,
effect.
Pardon?
It depends upon the practical effect of the order that your lordships are being asked to make. The crucial question is, can your lordships level down instead of levelling up? Can your lordships take away a provision which the Secretary of State has made by regulation? Or must your lordship simply extend that provision to the appellant? And I say that community law doesn't empower you to level down. It only empowers you to level up, in this case. Now, there may be cases where community law would allow you to take away rights, though it may be thought that would be an unusual consequence for persons who are not before the court. But if, for example, there were a complaint that the state had favoured a particular company by giving it special terms, then that's a matter which the parties could bring before the court, a competitor could bring before the court, and seek the removal of that benefit from that person. But we don't say that the grant of benefits to Irish citizens is incompatible with community law. All we say is that the failure to extend it to Latvian citizens is a breach where those Latvian citizens fall under 140871.
As I understand your paragraphs 177 to 179, you're saying, well, this could be achieved by the parliamentary route.
The Secretary of State can remake the regulations, absolutely.
But it's simply the powers of the court you're challenging.
Yes.
Is that right?
Yes, the Secretary of State may be able to equalise down, if he can do so in a way that's compatible with community law. He can also amend the regulations to equalise them up. But we don't seek, and have never sought, an alteration of the regulations, either to make them more favourable or less favourable. What we simply seek is the application of European community law to give the benefit of the regulation that is given to British and Irish citizens also to Latvian citizens. But we don't seek any amendment of the text of the regulation. And for example, if the appellant did not fall within the personal scope of Regulation 140871, and she had no other argument under community law that she could advance, she wouldn't be entitled to have the regulation be read as referring to persons with the right to reside in Latvia. It's only for persons within the material and personal scope of the regulation who can claim this right.
And the other point then, just looking at 180 to 182, is a point that severance really isn't achievable.
Yes.
Is that it? You're saying the substance of it can't really be altered.
That's right.
Anyway. And,
yes. And that's a domestic law point.
Yes.
So if you're against me on the community law point, I do say that applying Hutchinson, which I've set out the text there, and I don't think I need to take your lordships to it at this stage, yeah. That the alteration affects a change in the meaning. Now, the Secretary of State's response to that in his case is at paragraph 69 at page 34. Now, the first point to note, just under the letter D in the sentence, it is textually severable. That what the Secretary of State is inviting the court to do, if you're with us this far, is not only to remove the reference to the Republic of Ireland in the provision on right to reside, but also to remove it from Regulation 2.1, the reference to the Republic of Ireland in the scope of the habitual residence. So he's inviting you to take the step that Miss Flay in her witness statement said would almost certainly become a matter of a bilateral dispute. And I refer your lordships to page 100, for your lordships' notes, that's at page 117, paragraph 34. So the evidence that the Secretary of State relies upon as justification is that this would put the United Kingdom government in conflict with the government of the Irish Republic, but yet he invites you to take away these benefits from Irish citizens rather than simply, as we suggest, extending them to this appellant and to other persons in her situation, so long as the legal regime domestically remains as it is. The second point to note in response to this case is where the Secretary of State says below the letter E, the right of residence was originally intended to apply to a right to reside in the United Kingdom. Well, that's simply not true, and there's no evidence for that. And in fact, I can take your lordships, if needs be, to the Secretary of State's original proposal to the Social Security Advisory Committee, which clearly envisaged that the geographical scope of the right to reside test would always be the common travel area. And then the Secretary of State says that if that would be unlawful, the obvious conclusion is not that the UK would therefore extend the same treatment to all 25 other member states, but that it would return the regulations to their original intended scope. Well, as I say, There isn't any evidence that that was their original intended scope. But even if it were, even if it could be shown that some earlier stage the Secretary of State had thought of regulations in a different form, that doesn't mean that going back to them effects no change in the purpose, operation or application of the regulation as is required by Hutchinson. It simply means a change to some other purpose, operation or application which the Secretary of State has at some other time thought was a good idea. And in my submission, that's to go beyond the powers of the court under severance. So our submission on the Irish point is that it undermines the Secretary of State's essential justification on the rule. It gives rise to further impermissible national discrimination. It's not safe by the protocol and it's not severable. But none of that accepting all of our arguments does not affect the operation of the common travel area, does not affect the geographical scope of the habitual residence test, does not affect the situation of persons who fall outside community law, the benefits that they already receive. It neither removes them nor extends them. And it doesn't affect the Secretary of State's power to adopt a non-discriminatory test of connection to the United Kingdom. So, my Lords, in summary, for the whole case, we say that His Honour Judge Harris, President of the Appeal Service, who heard the matter at first instance, and is a former Chief Social Security Commissioner, was correct to allow the appeal for the reasons that he gave. I haven't taken you to his decision, but for your Lordship's note, it's pages 22 to 24 of the appendix, in particular paragraphs 11 to 18, where he has put that case much more succinctly than I've been able to. It's common ground that Article 3.1 precludes discrimination in respect to the conditions for this benefit for this appellant. It's common ground that the only basis for the refusal was that she lacks a right to reside, and it's common ground that British and Irish citizens have that right to reside by virtue of nationality. And we say that is prohibited discrimination because it is one that is met by virtue only of citizenship and not by virtue of any additional activity or requirements, and therefore it directly discriminates, and that direct discrimination cannot be justified, and that in any event the justification advanced is not independent of nationality. So what we would seek from your Lordships is a holding that the appellant is entitled by operation of Article 3.1 to be treated in the same way as a British citizen for the purposes of entitlement to state pension credit, including being treated as having a right to reside in the United Kingdom for the purposes of that benefit. And we say that argument is unaffected by the personal scope of Article 12. It's not affected by the supposed principle that member states must provide social assistance to their own citizens. And if it were necessary to decide it, state pension credit isn't part of the social assistance system of the United Kingdom for the purposes of the residence directives. My Lords, unless there's anything I can help your Lordships with.
I think the only point really that's left is the thing you deal with at page 38 of your case. This is the reference. Your position is that the reference is not required.
My Lord, that's right, because we say that if your Lordship is with us on what we say is the short route, which is that direct discrimination cannot be justified, or at least cannot be justified by considerations that are based upon nationality, because in principle direct discrimination relates to decisions that are based upon nationality and therefore cannot be justified. If your Lordships consider that it is not Act Clare that this is direct discrimination, and that it is not Act Clare that discrimination can be justified by considerations based upon nationality, then we would accept that those are suitable matters for reference to the Court of Justice, and it may be that your Lordships might consider other matters that have been raised are also suitable.
Yes. So on one view, on your argument, it's plain, but there may be other ways of looking at it which could give rise to a difficult problem which would require a reference.
Well, we have to accept that the Court of Justice did not take up Ellen Sharpston's request to make everything crystal clear.
Yes, that's been one of your points, that there are dicta by the Advocate General which have not been either expressly approved or expressly ruled out by the court, and therefore there is a question.
I accept that, my Lord, yes. I think that the strongest cornerstone of my case is the repeated proposition of the court that discrimination can only be justified by considerations independent of nationality. And We say that in this case, the considerations relied upon as set out in the Statement of Facts and Issues are dependent on the nationality of the persons concerned. The target of this provision is people who are not British or Irish. That's the deliberate target of the provision. And we say that the possibility of such discrimination being permitted is clearly ruled out on the case law of the Court of Justice, and that is Act Clare.
Thank you very much. Now, Ms. Pickup, do you wish to add anything?
I think he wants.
Thank you. Mr. Lewis, I think you speak next, am I right? Or Mr. Drabble follows you? Is that?
Normally it's Mr. Jarvis follows me because I've been replying to the intervener because he's with the other side, not with me.
Oh, I beg your pardon. Yes, so it is Mr. Drabble. I misunderstood exactly the
Well,
order
Lord,
of
I
events,
was
but
expecting to go next.
yes, I think that is right.
There's some
yes.
force in Mr. Lewis's
There
comment
is.
that although my case is
Yes.
not immediately not aligned in every respect with Mr. Cox's,
Yes.
at least in its secondary manifestation,
yes.
it's a matter that he
Yes, well,
Mr. Lewis will
let's hear from you.
may want to reply to. And my Lord, Lady, I wish to deal with three areas, as is plain from our case. My Lord, firstly, a very short word about the present state of play concerning the correspondence with the Commission and their view that there may be a breach of European Union law
Yes.
in relation to 1408/71. Secondly, a few words on the Sala, Trajani, Abdirahman, Kazmarek line of authority, recognising that the point of those submissions is to seek to persuade your lordships, my lady, that if there is a reference, it should be in terms which allow questions to be asked about what Trajani actually decides. And thirdly, some comments about the features of the 2004 Citizenship Directive. Well, before I come to those, can I just identify the target? Well, if your lordships will, my lady, will go to the judgment of the court below,
Yes.
which is at page 10 of the, well, if your lordship will go to it at page 10 of the appendix. A central part of the reasoning of the court below starts with paragraph 30, that Madam from Mr. Cox took your lordships to, and your lordship will see that there Lord Justice Moses indicates that it's important to appreciate that both this court and the Court of Justice have accepted as part of the ratio of their decisions the proposition that to preclude those who are not economically active and not self-sufficient from access to social assistance by depriving them of a right of residence pursues the legitimate aim of protecting the public finances and is proportionate to that aim.
Yes.
So that the approach that the Court of Appeal has taken is that what one might call the blanket ban on the payment of benefit, either of income support or of its successors, is axiomatically justifiable. The Court is entirely correct to say that that follows from Abdirahman and Kaczmarek, but it's an important part of our case that it does not follow from Trajani, and indeed the reasoning of Trajani is diametrically opposed to that proposition.
You're talking about the decision of the court in Trajani, or
The court,
Yes.
yes, a crucial part of what I think has gone wrong in my
Yes.
respectful submission of the English court's understanding of Trajani is that there is a very major difference between the approach of the Advocate General and the approach of the court on precisely this issue. I'll come to that in a moment. And one gets the same point in the judgment of this Court of Appeal in paragraph 52. Page 19, where the first sentence is making the point that the logic that was sought to be argued on behalf of Kaczmarek under Article 12 itself must apply, so the court holds, to Article 3 of 140871. It's the first sentence. Once it's accepted that state pension credit has not lost its characteristics of social assistance, despite its inclusion within the scope of 140871, it will be inconsistent with Trajani, Abdirahman and Kaczmarek to conclude that indirect discrimination in the light of the right of residence condition is unjustified. Once again, that's the blanket overall approach.
And it's putting Trajani with the other two.
And it's putting Trajani with the other two.
And it's right if you exclude Trajani from the sentence.
Yes. Yes. And that, I mean, I don't shy away from the fact that that was the point of the application for permission to appeal in Kaczmarek. Was essentially what was being said was that the conclusion that the court has drawn in Kaczmarek from and Abdirahman from Trajani is a misreading of Trajani. If your lordships then go to the Secretary of State's printed case, at paragraphs 56, 57 and 58, some central submissions are made, and I can identify what our differences are to those submissions as a matter of European Union law. In paragraph 56, the proposition is that the requirement that a person have a degree of economic or social integration evidenced by possession of a right to reside in the UK or the common travel area reflects the position under EU law at the material time that a non-economically active person is not entitled to reside in a member state unless he has sufficient resources. And then foot of the page and overleaf, domestic regulations which reflect that position cannot be said to be inconsistent with the exercise of the right to free movement recognised by the EC Treaty. Now, once again, we accept that the absence of resources is relevant to considering under EU law whether there is a right of residence. We do not accept the jump that is made from that proposition to the justification of a blanket ban. We say that the thrust of both the case law, including Trajani, and indeed the new Citizenship Directive, the 2004 directive, envisage decisions on an individual right to benefit being made on the facts of the individual case and being justified if benefit is refused or the EU national is to be expelled as proportionate on those facts. They do not envisage a national scheme under which the issue can simply not arise because the regulations say you can never qualify if you do not have an EU right of residence. We say that that approach, is it individual or can it be done by regulation, broad regulations, is an important and referable issue in itself. One constantly comes across the natural approach of the English court to say the proportionality must be settled in the scheme as a whole rather than the facts of the individual case. But in our submission, that is not what Trajani and the other cases like Gazelk envisage. In paragraph 57 picks up in its last sentence that member states are not, however, obliged, sorry, last two sentences I think I really need. He picks up the Advocate General's remarks in Trajani that EU nationals who depend on social assistance will be taken care of in their own member state under whatever system of benefits exists in that state. Member states are not, however, obliged to provide assistance to nationals of other EU member states who are not economically active and have not established the requisite degree of social integration in that member state. we respectfully adopt Mr. Cox's submissions to the effect that the court in Trajani did not follow the Advocate General and did not hold that EU nationals who depend on social systems will be taken care of in their own member state. And once again, we repeat the submission that the relevance of individuals not having resources to questions of rights of residence does not justify the blanket ban. And then there's then the Secretary of State's case.
What test is applied, Mr. on your approach?
On our approach, it's paragraph 43 of Trajani. You ask the question, has the EU national resided in the host member state for, and I can only repeat the formulation, a certain period of time? If the answer to that is yes, you ask, is it proportionate to look to either withdraw the benefit or expel? That line of thinking is carried over into the Citizenship Directive, particularly in Recital 16, which we recite in our case, and it envisages an individual decision. You will look at whether the absence of resources is temporary, what the consequences of expulsion are, and matters of that sort, and decide whether it's proportionate. I completely accept that the simple phrase, a certain time, creates its own difficulties. But the explanation that's been given by the national courts, I mean, in Kazmierik, and in the present court case, that it's referring to the fixed periods under which you could acquire rights of residence under the predecessors of 2004, the 2004 directive, is plainly, with respect, unsustainable. And there's nothing in any of the academic material under which anyone, other than Commissioner Rowland, to start with, has ever suggested that that's the explanation for it.
Sorry, to John, well, no doubt we're going to come to John, but I thought the court was very impressed by the fact that at some late stage the Belgian government granted the right of residence.
Well, that's the way that my learned friends are inviting the court to look at it. That's what the court actually very carefully says in paragraph 43. We will look at this in context because it's very important. Is that where an EU national has been resident in another member state for a certain time or has a residence permit, then he can rely on Article 12. Mr. Rowland has explained the reference to for a certain time as being a reference to accumulated time periods under the predecessor directives of the 2004 directive. But in context, it plainly isn't that. I'll show your lordships and my lady why. And for a certain time, one major possibility is that the reference for a certain time is deliberately there to deal with the UK system. Because very many, if not all, member states where a national exercises a right of residence, exercises a right of free movement, will issue a residence permit when the national is in the host state. And that may well be what happened in Mr. Trajani's own case. I don't think we actually know what what Belgian provision the right of residence was based on. But in the UK, it doesn't work like that, because you don't have any automatic evidence of your right or the fact that your residence is recognised as lawful. You simply come in without leave. And your lordship, my lady, may recall the Volcker and Remillion line of cases as to what the legal position was of people who were simply in the UK. You were EU nationals, were here lawfully as no doubt recipients of services for all sorts of other reasons. What is their position? The answer is they are here lawfully, at least in at least one sense.
Sorry, this appellant, what was her status? She was here, you say, I mean, she'd been refused asylum before accession. So what's her position after accession?
After accession, she is a EU national lawfully resident in the UK, we submit. The case against us is that on the approach that Abdirahman and Kazmierik have taken to Trajani, she is still outside the scope of the treaty because she doesn't have either a EU right of residence or a domestic right of residence, because her status as a non-removed EU national falls short of a right of residence. That's the case against us. We say that the approach that the court was taking in Trajani was precisely intended to avoid that sort of very subtle distinction arising. That's why the reference to a certain time is there. And the academic writings were full at the time of Trajani of speculation as to what a certain time might mean and how long did it have to be and so on. But no one explained it away on the basis that it was dealing with someone who had an EU right of residence because they clocked up time under another provision.
Well, you're coming to
to
show
that
us
in a
the
minute.
paragraph, I take it.
Yes. Yes.
Now, we were looking at 57.
Lord, paragraph 58,
Yes.
read together with the conclusion
Yes.
at paragraph 62, having cited Trajani at some length. Is to assert in the first sentence that the ECJ in Trajani considered that where a person had no right to reside under EU law or national law, he would not be entitled to claim entitlement to the minimex. Now, just to flag up the point, if your lordships go or look at the opposite page.
Well, you disagree with that?
Yes.
Yeah.
Yeah. I'll probably come to paragraph 43 in context
Yes,
in a moment.
we see 43, of course, on the opposite page. And
Yes.
Are you contrasting that with the first sentence?
With paragraph 43?
Yes.
Yeah, absolutely. And really the case against me is that the first sentence in paragraph 43 is an aberration. Well, we say it's very deliberate.
Yes.
So, well, those 3 points of difference are important. I go to them because I think my task is to persuade your lordships and my lady that the position is not at Clare against us from the point, in the sense that the Secretary of State's submissions in this part of their case are clearly correct. They are clearly correct on the authority of Abdurrahman and Kazmirek, but we say there is a major argument that they are not, those 2 authorities are not correctly decided.
So it's Act Clare in your favour, Mr.
Well, I don't think I can, because at least one member of the court rejected the petition in Kazmirek. And so I think it would be unrealistic. But,
I don't know. There are all sorts of reasons why one rejects petitions, which may have nothing to do with your speculations.
the reason given was that it was at Clare against me. And I've been unable to find the actual order. I think it was at Clare against me because the court accepted the view of the Court of Appeal that the issue of proportionality had been settled generically by the time period under the Citizenship Directive. Now, when we come to the detail of the recitals of the Citizenship Directive, we say that's not a tenable view, and therefore the matter is not at Clare. Now, just a very short...
Yes, I mean, you are on a 1 hour...
I'm aware of that. Can I then just take your lordships very shortly to Sala and Trajani. The background, as your lordship and my lady will understand, is that these were 2 cases that followed shortly on the introduction of the concept of European citizenship in the Maastricht Treaty, and the creation of a freestanding right of residence in what was first of all Article 8A of the treaty, albeit subject to the conditions of the various implementing regulations and directives. And in both Sala and Trajani, the National Court referred questions that were aimed at establishing exactly how powerful was this apparently freestanding right of residence. The answer that came back in both was that the right of residence was still subject to the conditions in the directives, which included self-sufficiency. But that if you were lawfully resident in the host member state, you didn't succeed on the basis of Article 8A, as it first of all was, or Article 18. This case is bedevilled by the fact that Article 18 starts out as being the residence provision and ends up being the anti-discrimination provision in the modern version. But anyway, the outcome in both Sala and Trajani was that the lawfully resident individuals succeeded not on the basis of their lawful residence or any directive rights, but because being lawful resident, they were both within the scope of the treaty, in the sense that social assistance security benefits were within the scope of the treaty, and they were within the personal scope of the treaty because they were EU nationals lawfully resident in another member state. And if your lordships go, my lady, go to Trajani, volume 6, sorry, Sala, first of all, volume 6, tab 71. I won't read any part of the Advocate General's speech, opinion. But if your lordships glance at it in due course, your lordships will see that it's concerned with investigating the limits of the first right of residence in Article 8A. The obvious reference is at page 12701 in paragraph 15. The whole background is how much difference does 8A make? The Advocate General answered the question relevant to the 8A issue at page 12707. Question 4. A community citizen authorised or allowed to reside or stay in the territory of another member state is entitled to benefit on the same terms as nationals of that state. So his formulation was authorised or allowed to reside in the territory of the member state. And to answer my Lord Brown's question about the status of the present claimant, she is being allowed to reside in the territory of the member state. Now, the court doesn't take exactly the same route. The critical passage is the passage of paragraph 55 through to 65.
Yes, we looked at this
We looked at it yesterday. I need just to draw attention when we go to see what's happened in the domestic case law, to draw attention to paragraph 57, which holds that child raising allowance falls within the scope of community law. Although it's expressed as a bland statement, it was something of a revolutionary statement at the time. Social security benefits by themselves are within the scope of the treaty. Then paragraph 61, as a national of a member state lawfully residing in the territory of another member state, the appellant in the main proceedings comes within the scope rationae personae of the provisions of the Treaty on European citizenship, and then the conclusion follows, in paragraph 64, since the unequal treatment in this question thus comes within the scope of the treaty, cannot be considered to be justified, this discrimination directly based on the appellant's nationality, and in any event, nothing to justify such unequal treatment has been put before the court. So that's first of the right of residence cases, where the court solves the problem not by 8A, but by what was then 6, the general
I'm sorry, this is
anti-discrimination.
a very basic question, but I find it so difficult to get my mind around much of this. I mean, so you start by asking whether the person, so to speak, prima facie falls within some right to the benefit. Is she a person who qualifies, he or she, and is it a benefit which qualifies? And only then do you go on and ask yourself whether they can be, so to speak, excluded under some justifiable discriminatory measure.
On this passage in Sala, the court thought it sufficient to ask and answer just 2 questions. One, was the benefit within the scope of the treaty? Answer, yes.
That's 57.
And that's 57. And as I say, that was regarded as a fairly novel proposition at the time. But question 2, is the claimant within the personal scope of the treaty, which is the, I'll put it away
61.
now, but 61.
I know. But then why do you get into discrimination at all then?
Because once you get that far, you go back to Article 6, as it then was,
And now
which
is
prohibits discrimination within the scope of the treaty. Sorry,
Yes.
I'm probably taking it one stage too
and 6
too
is
quickly.
12 now, isn't
6
it?
is now
12.
6 is 12.
Yes.
I think 6 is deemed 12. Yes,
right.
6 is 12 for the purpose of this case. It has now become 18, confusingly. Sorry, that's a completely unnecessary complication. 6 is now 12.
Yes. All
Yes.
right.
Yeah.
So she's within. She's
So you're-
protected by 6.
Yes.
And 12.
So
being
the
12.
target the court is aiming at in those 2 paragraphs of Sala are, is this a matter falling within the scope of the treaty?
Yeah.
Because if it's a matter falling within the scope of the treaty, then you can say without more that discrimination on the grounds of nationality is prohibited because of 6, now 12. That's the way it works. So that you...
Yes. There are 2 puzzles, aren't there, in the way 64 is worded, because the first one, it seems to me, is that it doesn't distinguish between direct or overt discrimination and covert. It treats the 2 pari passu, it just simply uses the expression discrimination, and so far as the court is concerned, it looks as though that distinction hasn't really emerged as part of its thinking.
Yes.
And then the second point is the point about justification, which, reading the sentence as it's put, suggests that it might be possible to justify unequal treatment on a ground that was related to nationality.
Yes.
And we don't know the answer to that yet.
But I completely accept that. That is very much Mr. Cox's part of the case. I mean, he's been, as I understand it, trying to persuade the court that the answer is in fact clear, because this is discrimination directly based on the appellant's nationality, to use the language of paragraph 64. But I think my sole role on behalf of the Air Centre is to seek to persuade the court that if there is to be a reference, which will only arise if Mr. Cox doesn't persuade you, is that clear, that there is an unanswered question about what the court actually meant in paragraph 43 of Trajani, which should be referred at the same time.
Well, that's Sala. Is there any more we need to take out of that?
No.
No. Shall we go?
So we now go to Trajani.
Trajani, yes.
Yep. And that is in volume 7. Sorry, at tab 79. The court will go straight to page 837 where in the Advocate General's opinion, and in AG 70, paragraph 70 of his opinion, he's at this stage dealing with the right of residence part of the case, and he says the basic principle of community law is that persons who depend on social assistance will be taken care of in their own member state. I say we accept Mr. Cox's submission that the court does not agree with that, indeed plainly doesn't agree with that.
I didn't pick up the paragraph number, I beg your pardon.
It's AG 70.
70.
Yeah. Last sentence.
Oh, yes.
The whole passage up to 71 is dealing with the questions that the Belgian court had referred, which were all to do with rights of residence. Didn't raise any issue of discrimination, direct or indirect. Didn't raise any discrimination issue.
Yes.
And in paragraph 72, he says, my views on this suggestion of unequal treatment are as follows, and then he said, well, we'll come to what he says in a moment. It's obvious that a debate had broken out at the hearing about the relevance of Article 12, because he says, nevertheless, I consider it reasonable to devote a few remarks to the subject in the view of the attention it attracted during the procedure. And then he says, his view is that the answer to the question whether the case involves prohibited discrimination or by reason of nationality depends on the right of residence status of the citizen of the European Union, and goes on to deal with that. And recognises that if Mr. Trajani had in what we in England would call, what he does call, indefinite leave to stay, based upon a solely domestic provision, then discrimination might be prohibited. But in 74, he recognises the essential fragile nature of Mr. Trajani's right, if that's the right word, to be in Belgium. If, on the other hand, as according to the file happened in this particular case, a temporary residence permit is issued in the hands of CABA 2, and in the words of the CABA 2 judgment, the Union citizen combined does not have the unconditional right of residence, that citizen cannot claim social assistance from the member state, even on the basis of the non-discrimination principle. So
that's
it's a knockout blow.
That's a blanket proposition.
Absolutely, it's a blanket proposition. And the Advocate General, and presumably therefore the court, are fully aware of the very fragile nature, if I may put it like that, of Mr. Trajani's right of residence. So at the high policy level, the question is, why should it make, like a question posed by Mr. Cox, why should it make a magic difference? Instead of being here for, say, 2 years under the UK system without a residence permit, but no attempts being made to exclude you, your Belgian comparator, being here for 2 years, has a residence permit which can be revoked for recourse to social assistance. Why does that make the magic difference? And when we come to look at what the court says, it's page 843. Dealing with the second question, paragraph 30, in my respectful submission, is important for setting the context of what is said later. The question the court is confronting, when we come to paragraph 43, inter alia, is whether a person in the situation of the claimant in the main proceedings may, simply by virtue of being a citizen of the Union, enjoy a right of residence in the host member state by direct application of Article 18. So we're axiomatically, in the following passage, dealing with someone who does not have a right of residence under the various directives that preceded the 2004 directive. Belgian court is asking the fashionable and legally sensitive question, does Article 18 produce the same effect? To which the answer is no. But it is nonetheless relevant because the court, having agreed with the Advocate General that the conditions of the earlier directives were still relevant to the right of residence, then goes on to address an issue which hasn't been referred, as your Lordship saw yesterday from paragraph 37. We'll go on to say we'll give the member state, the national court, as much help as we can. And then paragraph 39 refers to Article 12, and paragraph 40 says it must be stated that while the member states may make residence of the citizen of the Union who is not economically active conditional on his having sufficient resources, that does not mean that such a person cannot, during his lawful residence in the host member state, benefit from the fundamental feature of equal treatment as laid down in Article 12. And then 42, within scope, that's a repeat of Sala. Minimex within scope. And then paragraph 43 has what in our submission is a very careful formulation. With regard to such benefits, a citizen of the Union who is not economically active may rely on Article 12 where he has been lawfully resident in the host member state for a certain time or possesses a residence permit. The case against me is that that reference to a certain time is explicable on the basis that it's a reference to completed time periods qualifying for rights of residence under the various directives. But if we go back to paragraph 30, we're clearly not dealing with that. We're dealing with someone who doesn't have any right of residence other than the treaty. It's the whole context in which the Belgian court asked the trendy question, if I can put it like that. And I repeat the observation that Secretary of State has never produced anything emanating from the Commission or any academic writing or any other materials at all to suggest that the court was referring to the previous directives when it referred to resided for a certain time. Our submission is simple. It means what it says.
Mr. Also, 42 and 43 here, you say are equivalent to 57 and 61 of Sala. Is that it?
Yes. They're answering the same questions that are necessary for what was now Article 12. So if you imagine a situation, it's not quite Miss Patmalniece's, but imagine a situation of someone who is here, comes to the UK with sufficient resources to have a right of residence under the self-sufficiency provisions. Something goes wrong, bank goes bust or something of that sort. She no longer has those resources. She doesn't have a right of residence under the self-sufficiency provisions, but she will have been here for a certain time, and she will be able to rely on Article 12, according to the court. And then 44 says that this discrimination is prohibited, and then 45 is a very important submission, a very important paragraph.
Yeah, so how does it mean he comes as under 18? She gets a right of residence under 18, is that right?
She doesn't get a right of residence.
Sorry.
That's the point.
That's the whole...
Doesn't
that's
get a right of residence, but if she actually has one,
yes.
then she benefits from
Yes.
the non-discrimination in Article 12.
Exactly. And we say, apply that line of thinking to a UK system where there are no residence permits for EU nationals who travel. The issue is, to use the words of this, is she lawfully resident in the host member state for a certain time? And we say the answer is yes. So go back to my self-sufficiency example. You have someone who, on my self-sufficiency example, has exercised a treaty right of residence, that is, the treaty itself plus the 2004 directive, to use a modern example. She ceases to fulfil the conditions for the treaty-based right of residence, what's the consequence for her benefit entitlement? The answer is that she can rely on Article 12 if she's been resident here for a certain time. A certain time, no doubt, filters back into thoughts about social integration and matters of that sort. But that's all that the court has said.
So it's my fault entirely. But on what basis is she a lawful resident?
She is in the United Kingdom.
Yes, I understand that.
Lawfully, because she's exercising free movement rights. She isn't given a right of residence in the sense provided for by the Citizens Directive, but she's here perfectly lawfully, unless the member state chooses to expel her.
I'm looking at paragraph 60 of Sala just to see if I can compare the situation there to see how this works. Because in Sala, the way it's put, this is Sala in tab 71 in volume 6.
Yeah.
And we're page 2725. And as I understand it, in Sala, she'd been refused the issue of a residence permit. So she doesn't possess a resident permit, to pick up the words in Trajani, paragraph 43. But it was common ground she'd already been authorised to reside there.
Yes, the basis of that is very unclear, but yes, it is. It did proceed on the basis that it was common ground that she was authorised to be there.
So in a way, she's in the sort of certain time bracket.
No, I don't think she is. I think Sala is. I think I would accept that Sala is an example of express authorisation, as far as one can penetrate what is happening in Sala. It's very unclear. Yeah. And of course, I've already drawn attention to the Advocate General's formulation: authorised or allowed to reside. So that you have, in the UK system, someone comes here, may well be exercising rights of residence, i.e. doing something which they're allowed to do by the Citizens Directive, which gives them a right of residence. They then cease to fulfil the conditions of the right of residence. So residence doesn't become unlawful just because of that fact. They are here as a EU national who is, I'm happy to say, tolerated. Whose presence is tolerated in the member state.
So tolerated trespass.
Could be removed, but hasn't been.
Could be removed, but hasn't been, exactly.
But simply here.
Yes.
I'm sorry, and you said of this appellant that she is lawful in the UK because she's exercising what rights?
Well, she's an EU national who is given by the treaty the right to enter another member state. She doesn't need to be economically active to do that.
So is this the Article 18 right of
I don't think it's
freedom of
Article 18, no.
So what is this right?
Yeah.
The right to enter is under Article what?
What is the main? The UK.
I thought it was Article 18. But maybe I'm wrong.
Mr. Drabble, I understood you to be telling us about half an hour ago that the general message of Sala and Trajani that was to see how strong the freestanding right of residence conferred by citizenship was, and that the general message we were to take was that it wasn't all that strong. And I don't understand where we're getting to now. I really don't see what you're saying to us about it. I'm sorry.
Okay. Put that right there once.
No, don't try, but I find it very, very difficult I really wonder whether oral advocacy is helping us in this case. I have to say it. We've been here for a day and a half now, and it's just getting more and more muddled.
Well, I'm sorry about that. Our thesis is that the courts in what I was saying earlier, let's just answer it as plainly as I can. The courts in Sala and Trajani were being asked questions about how strong the new right of residence was. The answer came back that as far as a right of residence was concerned, you didn't have a right of residence unless you met the conditions of the subsidiary legislation, and that, as your lordship will appreciate, is compatible with the wording of Article 18, or
Yes.
18 as it then
Subject
was.
to limitations and so on.
Exactly
Yes.
right. But the court was nonetheless anxious to give a wide protection against discrimination by resort to the anti-discrimination provisions and adopted a wide construction to what was then, at the time of Trajani, Article 12.
Sorry, I'm losing my track of numbers now. Article 12 is
Was
42.
6. Was 6.
Yes.
Is now 18 and was 12 at the time of the material.
Oh, don't!
No, I know, it's running. In Trajani terms, said we don't get the answer out of 18, and the Advocate General is right to say we don't get the answer out of 18. However, someone who has been resident for a certain time or possesses a residence permit can get the answer out of 12.
That's what I thought you were saying. And in a way, it doesn't matter why the person is lawfully resident in the member state in question, the host member state. So it's a bit of a distraction to talk about them exercising any of their community rights. They might have got here for all sorts of other reasons.
Yes, and that in our submission is the basic message of Trajani,
Yeah.
that the court and the Advocate General, the Advocate General and the parties spend a very long time debating whether or not there is a right of a treaty-based right of residence.
Yes.
And the Advocate General answers that in the passage just before he considers the discrimination point. He's correct on that, and the court agree with him on that.
Paragraph numbers.
Let me just go back to Trajani. Advocate General answers that question up in the passage up to and including
It's AG
paragraph
70.
71.
70, because then he goes on to 71 to raise the discrimination
It
point.
does indeed. It's 70,
Yeah.
yes.
So he answered it correctly at 70.
He answered it correctly at 70, save for our caveat about this.
Save for the
about
final
social
sentence,
assistance.
yes.
Exactly.
Yeah. And the court agrees that what?
The court agrees
At 33, I think it is, isn't it? Is it?
Yeah, I think it's
33 and
36.
36, yes.
It's yeah, 31 to 36.
Well, 36 says it does not derive from Article 18.
That's right. Does not derive the right to reside.
Yeah, exactly.
So agrees with the Attorney General,
Yes.
the Advocate General.
The Advocate General.
Always say, dearie dear. But then they go on to discuss discrimination.
Yes. They
And
go on to
say
say-
if you're lawfully resident, at least for a certain amount of time.
Yes, and then it's Article 12, isn't
Yeah.
it? Paragraph 39.
Absolutely. And when we
No, time is running rather against you, Mr.
yes,
Trump.
I realise that. Can I go as quickly as I can? Paragraph 45, if you've got this passage open,
Yes,
is important.
in Trajani.
In Trajani,
Yes.
so page, page 844. Should be noted that it remains open to the host member state to take the view that a national of another member state whose recourse to social assistance no longer fulfils the right conditions of the right of residence. In such a case, the host state member state may, within the limits imposed by community law, take a measure to remove him. However, recourse to the social assistance system by a citizen of the Union may not automatically entail such measure. And the reference is to Grisel, because that's the correct pronunciation, paragraphs 42 and 43. We provide, those are on your desks, but I won't take you to it. So 45 is an important, and its predecessor in Grisel, paragraphs 42 and 43, are important for our submission, that what the court envisages is that expulsion decisions are going to be made on a case-by-case basis and have to be proportionate. And if, as it were, a refusal of benefit is a proxy for the expulsion decision, then we say exactly the same logic applies. The refusal of benefit must be proportionate on a case-by-case basis. So that's Trajani.
So it's a national rather than every national, in a way. Is that the point, really, that, again, it's not talking about a blanket solution, it's looking at the individual?
Yes, absolutely. So go back to my example. A person who comes here who is self-sufficient, ceases to be self-sufficient, what can the member state do? It can certainly say you no longer fulfil your condition of residence. That's what's being envisaged in 45. But you have to do so within the limits imposed by community law and on the basis that recourse to social assistance doesn't automatically lead to that consequence. It's a case-by-case basis.
I've had just a quick glance at Griselda, or whatever she's called. The student, again, it puts this way, it doesn't, the member state's not prevented from taking a view that a student has a recourse to social assistance no longer fulfills the conditions.
Yes.
So it's the same point.
It's the same point. And it's important for these purposes because my last port of call in this hour, I can just about do it, I think, is the Citizenship Directive.
Yes. Yes.
Which is at tab 26 of volume 1, sorry. If your lordships will, my lady will first of all just glance at our case. We have set out our submissions on the structure of this directive, which, as it were, consolidates the previous directives in paragraph 10 of our case. Which is the effect that the Air Centre's basic contention is that the drafting assumption behind the 2004 directive, who exercise that right of residence, will be entitled to social assistance. Expulsion may be possible, but this cannot be the automatic consequence of recourse to social assistance, and substantial procedural safeguards are created by the directive. And then we repeat that submission on the structure of this directive in paragraphs 14 and 15.
I mean, you're not saying this appellant exercised the right of residence created by the directive, are you?
I'm not. No, the directive came into force in 2004 with an implementation date.
30th of April 2006.
Yes, either 2 or 4 years, depending on the particular provisions.
But we did it.
Well, we did it. We implemented by 2006. So the facts of this case fall in the course of the emergence of the directive.
Is that the claim here was in 2005, in August, is that?
Yes.
That point, and it falls outside the...
Casmeric fell outside the directive, although your lordships will have seen that the court in Casmeric relied on the fact that you only got your permanent right of residence after 5 years as an indicator of proportionality. the sort of length of time that would be regarded as proportionate.
I'm assuming 20 minutes, 20 past was the time, but if you've got
Right.
just a few words to finish off with, Mr.
Yeah.
Gravel.
Well, if 20 past is the time, can I then just draw attention, or can I just do two things, hopefully not trespassing too much? We've set out in paragraph 14 of the case, which I hope your lordship still have open, recital 16 of the directive. Your lordship will see that uses language which is closely based on the paragraph of Trajani and the earlier paragraphs of Grizalk that I've taken your lordship to,
Yes,
and my lady to.
yes.
So that what appears to have happened is that the directive summarised the case law, codified the law, reenacted the case law, as recital 16 demonstrates, on the basis that there would be individually proportionate decisions if there was going to be a question of expulsion. And my lord, finally, can I just refer your lordships to the article that was written by the Assistant Director of the Air Centre, which your lordships will find tab 84 in volume 7.
Where do you refer it in your case?
Refer to it,
Paragraph 13.
paragraph 13, and very grateful. I just take your lordship and my lady straight to page 252. The article is discussing generally the lawfulness of expulsion, so its main focus is not benefit entitlement. But your lordship will see, my lady will see at the top of page 252, Mr. Vice says, paragraphs 1 and 3 of Article 14 seem to assume, however, that EU migrants will have at least temporary access to the social security system, social assistance system. It's hard to make sense of those provisions otherwise. And then recital 16, both of his inference, and we set it out again, but I've taken...
Yeah.
And then there's a flowchart, which is, in terms of understanding it, as valuable as anything else, in my respectful submission of what we say is actually the scheme of the 2004 directive. You come in, you exercise your treaty rights, you hit temporary difficulties. The structure of the directive assumes that you will be able to access social assistance, if that's the right phrase, anyway, some means-tested benefits on at least a temporary basis. Authorities may verify if the individual still meets the conditions for residence. And if you don't, and it's proportionate to take an expulsion decision, then you can take an expulsion decision. Well, those, I think, are my submissions. Save to, I think I said I would tell the Lordship the position about the Commission.
We have,
will no doubt tell you that.
we have a letter of the 18th of November. Is that the point you're going to mention?
Yeah, there's a slight update. If your Lordships have the letter of the... There's a letter of the 11th of February 2010, tab 55. 85. Sorry, tab 85, I'm sorry. And then the 2nd of July 2010, next tab, must be 86. The point that I wish to be clear about, that letter of the 2nd of July refers to letters of formal notice sent on the 4th of June 2010. So, my Lord, tab 86. my understanding of the actual position is this, that there were 2 letters of formal notice, one addressed to issues concerning A8 nationals and the right to reside, not the right to reside, just the worker registration scheme, the Zaluska points, and the second right to reside, sorry, the second formal notice related to a legal approach similar to Mr. Cox's, that there might be discrimination contrary to Article 3 of 140871. A formal opinion has been issued in relation to the A8 national issues. No step has been taken in relation to the 140871 issues, either to indicate that they were not being taken further or to issue a formal opinion. It's still being, it's my understanding, still being considered. But those, I think, are my submissions. Unless there's anything else on which I can help.
Thank you very much. Mr. Bano, you're not in a position to address us even if you wish to. Mr. Lewis?
My lords, my lady, this case is a great deal simpler than it has been made to appear. There are 3 issues in this case. First,
Not too fast, please, if you're going to start reciting them.
First, do the conditions governing entitlement to state pension credit give rise to direct or indirect discrimination? Secondly,
On grounds of nationality.
no, I'm going to leave it as I'm.
You're
as I
going to
put
leave it without any...
Yes.
Oh, I see.
I'm saying direct or indirect discrimination. I'm summarising the issues. I don't want to complicate them unduly at this stage, my lady. I'll be telling you in my submissions what is direct and what is indirect and so forth. But for the moment, in order to keep it simple, because we've become quite complicated, first, do the conditions giving, with all due respect, first, do the conditions governing entitlement to state pension credit give rise to direct or indirect discrimination? Secondly, if the conditions give rise, as the respondent contends, to indirect discrimination, are they objectively justifiable?
Yes.
And thirdly, is the conclusion on that issue, objective justifiability, affected by the position in relation to those habitually resident in Ireland or other parts of the common travel area? Is it direct or indirect? If it's indirect, is it justifiable? Is that changed because of Ireland? And those are the 3 issues in the case. I propose to divide my submissions into 3 parts. First, I'm going to summarise our case on the issues. Secondly, I'm going to consider in some detail the conditions governing eligibility for state pension credit. Your Lordships may have been left with the impression it's a relatively narrow worker requirement. It is far, far broader, and your Lordship needs to have a grasp of the conditions to assess justifiability. And then thirdly, I'll consider and deal with the questions that my Lady Hale raised in relation to each of the 3 issues, indirect, direct, and so forth. My Lords, my Lady, we have summarised our case, just for your Lordship's note, and lest I go at undue speed, at paragraph 4 of our case, and I can set it out in 4 essential steps.
Just before you do that, it struck me that it is helpful just to remind ourselves of the undisputed matters.
Yes.
Because there's quite a neat list in
Yes.
the statement of facts and issues, which takes us some distance, I think, through the materials.
Yes.
And it really carries on to really about paragraph 33 is where
Yes.
one gets into disputed area.
Your Lordship needs to be careful about paragraph 33. It's been represented in a way that was not intended, certainly on our part, and maybe we like everyone else, it appears in this case with Mr. Trick, this is the justification that applies in her case.
Yes.
The justification for the rules set out in the Secretary of State's statement, which I'm going to take your Lordship to in detail, and it's set out in the Court of Appeal, as is referred to in paragraph 3 at 27, and in more detail at 46 and 47 of the Court of Appeal. And I'll be telling you what that is. And on the particular facts of this case, we were dealing with a non-economic European Union migrant who couldn't support herself.
Yes, well, you're in trouble too much, Mr. Lewis. I mean, I'm just suggesting that when we get to 33, that's debatable ground.
Well,
And
it's an oversimplification of the position.
yes. Yeah, well. Anyway, one can work through all the agreed materials there, and that's the starting point for the discussion.
Yes. But if your Lordship turns to page 4, paragraph 4 on page 3 of my case,
Yes.
it's we've set it out in 9 steps there. I'm going to summarise it in 4. But just so your Lordship understands the shape of the case and where we come from and how we say the case is anchored, rather than the many highways and byways that we've followed. First, we say the true requirement for eligibility is that a person be in Great Britain. But in any event, neither the requirement that a person be in Great Britain, nor that aspect of the test dealing with the need to have a right to reside, involves direct discrimination. That'll be our first submission, and I'll deal with it in a short while. But the first part is the true requirement is in Great Britain, but in any event, neither the test that you be in Great Britain, nor that part of it dealing with a right to reside involves direct discrimination. Secondly, we do recognise, however, that the requirement that you be in Great Britain or that you have a right to reside is more likely to be satisfied by UK nationals than other EU nationals. And to that extent, the conditions give rise to what we call indirect discrimination and will need to be objectively justifiable if they are to be lawful. And I've really done subparagraph 5 and 6 for your Lordship's note.
Can I just ask you to pause there? You introduce justification at branch 2, or point 2, rather than point 1.
Yes.
So if we were to conclude against you that this was direct discrimination, are you attempting, or would you be attempting to suggest that a justification argument could be raised?
We have not suggested that on the facts of this case you could justify direct discrimination, because we have seen it as indirect discrimination. The long answer, so the short answer is we haven't sought to do that here, no. The long answer is we say the true position is direct discrimination is by reference to nationality, and therefore it's going to be very difficult to consider justifying it. And indirect discrimination is broader. Anyone may qualify in theory, but in practice it's more difficult if you're not a UK national. And that's why very often one talks about direct discrimination not being justified, because it's dealt with so narrowly. If this court is going to find that direct discrimination is much broader and covers the sort of matters that the appellant says is within the scope of direct discrimination, then you really will have to consider whether or not justification applies to what is within the scope of direct discrimination as you've then explored it. So if, as we say, direct discrimination is really by reference to nationality expressly or patently by reference to nationality, then the likelihood that you'll be able to justify it is very limited, although the court has never formally said you can't. But if you start expanding the scope of direct discrimination to bring within it many new types of rules that wouldn't previously have attached that label, then the scope for justification becomes a much more acute issue.
So on the Eleanor Sharpston formulation, you might very well have to consider justification.
Absolutely. Had she been correct, we would have had to consider really her footnote 97. Was the court, when it made that qualification in Martina Sala, really saying something important, or was it, as she says, an afterthought? So we say, firstly, direct in Great Britain, but in any event, it's indirect discrimination. Secondly, because it's indirect discrimination, it has to be objectively justifiable to be lawful.
Yeah.
Thirdly, in our submission, the requirements are objectively justifiable. The conditions ensure that any person who can demonstrate economic integration in the United Kingdom, or a sufficient
A
degree
little
of...
bit slow.
You're talking very, very fast. And
I thought I was
To
going
ensure
slower
that
than
anyone
usual.
who can.
Anyone who can show whatever it was.
In our submission, the conditions ensure that any person who can demonstrate economic integration in the United Kingdom, or a sufficient degree of social integration in the United Kingdom, are eligible. And I'll show you the breadth of the conditions shortly. But the requirements seek to prevent the exploitation of welfare benefits by persons who seek to come to this country and to live off such welfare benefits,
Anyway, who seek to come to this country
and to live off such welfare benefits without working and without having a sufficient connection with the United Kingdom.
no, you use the expression welfare benefits. Does that cover both social assistance and social benefits?
No, it's social assistance,
It's
not social
assistance.
security, yes.
Right.
It's social assistance and those benefits having the characteristics of social assistance to be more accurate about it. But it's not social security per se.
Right.
It's state pension credit, it's income support, it's those matters.
It was without
The Article
working.
4.2a, the Article 4.2a and 4.4 benefits.
Basically, the means-tested ones. Isn't it?
It's the income-related ones, yes.
Yeah.
We call them income-related, my lady, but yes.
Well, you can call them what you like. I call them means-tested.
Yes, but just so that we're not at a confusion, when your ladyship says means-tested, I'll be saying incomes-related, but it's
So
the same
if,
thing.
if they're listed in Appendix 2A, then that's all
The
right.
2A and the 4.4, yes. Yes, the 4.4 and the 2A. The hybrid ones
Yes.
and the only social assistance ones.
The other ones, they do have an entitlement to.
Yes, if they're social security within 4.1, they will have an entitlement to them.
Straight, non-hybrid.
Non-hybrid, non-social assistance, social security benefits, there is no right to reside test for those. Oh, I'm told there may be an issue about child benefit, but there's always a wrinkle. But child benefit
Not always, it's not
apparently
an issue. Child benefit is subject to the same test.
Yeah, right. Well, child benefit may be one separate issue, but as a broad line analysis, social security simpliciter in 4.1, you're not subject to these right to requirement tests, but a hybrid 2A or a social assistance and can't be anything else 4.4, that's subject to these requirements. And then there's one or two like child benefit, which are, I'm told, different.
Yeah.
But standing back from it, those who have economic integration, social integration, will have access. Those who come to the UK to live off such benefits without working or having such a connection will not qualify. And then fourthly, and we say that is objectively justified, and I'll be showing your lordship the decision in Zaleska, which accepts that that's a legitimate purpose, and I'll be saying that it's consistent with the legislation and with the case of Crown, or at least with the majority of Zaleska.
You've got two who are against
But
it.
not on this issue, my lady. You were with us on the other issue. So that's the first three of the 4 points. The fourth point that is this. We say they're objectively justifiable, and insofar as the requirements relate to a right to reside in the United Kingdom or the Republic of Ireland, or the Common Travel Area, that simply reflects a particular situation arising out of the economic, historic and social links between Britain and the Republic of Ireland.
And
That
questions
situation
of reciprocity, you say don't matter.
I'll come to that in just a moment, my lord. Can I just go
Yep.
through it in order?
Can you just dictate this fourth proposition?
Yes. Insofar as the requirements relate to a right to reside in the United Kingdom or the Republic of Ireland, that reflects a particular situation arising out of the historic, economic and social links between the constituent parts.
Arising out of what?
The historic, economic and social links between the constituent parts of the British Isles. That particular situation does not exist in relation to the other 25 member states. Poland, Latvia, even France, Germany, so on. And our first point is that simply because we recognise there are specific considerations governing the common travel area does not undermine the justification in relation to the rest of the world, the other 25 member states and countries outside the European Union, and doesn't prevent us treating the rest of the world different from the common travel area. That's the first point. It doesn't undermine the justification. Secondly, and in any event, we say the arrangements are justified and fall within the scope of Protocol 3. They are arrangements relating to free movement between the Republic and the United Kingdom, and I'll take you to the evidence. Arrangements do not have to be reciprocal. I may invite your Lordship to dinner. I may hope your Lordship will reciprocate, but I have still made an arrangement to invite you to dinner. So reciprocity is not a requirement of an arrangement relating to travel, but if reciprocity is required, it is present, because the Irish test, which is different from ours, has been constructed in a way that makes the same presumption about residence in the common travel area. So the reciprocity, if it has to be there, is there. Next, if I'm wrong about Protocol 3, and if it doesn't come within Protocol 3, what is the consequence? The consequence is that there is indirect discrimination, because it is more likely that Irish nationals will be able to show a right to reside in the Republic of Ireland than other EU nationals, like Latvians.
Yeah.
And we say it is objectively justifiable because of the historic, economic and social links that have existed between our two nations for so many centuries. If I'm wrong about all of that, and it was unlawful to give treatment in respect of the right to reside in Ireland because it resulted in unjustified indirect discrimination, then what your Lordship does, as a matter of ordinary domestic law, is strike out the relevant words from the regulation. It's not an EU law point at all. Where regulations are made in the exercise of a statutory power, and the regulations are good in part, but bad in part, there is a test established by the House of Lords which tells you when you can sever or strike out the bad, and I'll show you that we meet the test for severance.
You have to look at the overall effect of doing that, though.
Exactly. And the first thing is you can clearly do it textually because you can strike out the words "or the Republic of Ireland." And secondly, you ask yourself, is it substantially severable? And the question is, would the United Kingdom have done what Mr. Cox says and said we must give it to all 25 other member states if we can't otherwise give it to Ireland? Or would they have given it to the UK and not to Ireland? And the answer is, we know the position with reasonable certainty, because the original proposal on habitual residence, I accept I've made a mistake in the case, I should have said habitual residence, not the right to reside. We had the test for habitual residence, which the subsequent right to residence is then built into. And that habitual residence test was intended to be only for Ireland because of the historic links between, only the United Kingdom.
UK.
It is extended to Ireland because of the historic links with Ireland. Now, if it transpires that those historic links don't justify the favourable treatment for Ireland, it is inconceivable we would have said, well, in order to make sure the Irish have it, we will give it to all other 25 member states and 340 more million people. So in my submission, it is textually and substantially severable, and it's a straightforward domestic law matter. It's like getting a bylaw which applies to England and Wales, and you've only got power for England. You strike out the or Wales, and everyone is perfectly content, well, except the people in Wales. But
maybe to their advantage.
well, maybe to their advantage. But it's the same point here. If the regulation shouldn't have included all the Republic of Ireland, you strike it out. And this is not a question of, oh, what is the scope of Section 2 of the European Communities Act? What is the scope of EU law, and what are the powers of this court? The Secretary of State has power to make regulations that are lawful.
Well, Mr. Lewis, this is just a summary at this stage,
yes.
so we'll be coming back to all these points later.
I'll come back to it, but those are the summary 4 grounds, summary 4 points that I want to make. 3 issues, and I've summarised in 4 points the grounds.
Right.
Can I then deal with the first part of my submissions, which is the conditions governing eligibility? And I'm afraid I'll ask you to take up Volume 1, and I'm afraid I do need to take you through a lot of the legislation, so your Lordships understand it is not just workers. There are a whole range of other people with social integration who are covered, and it's essentially only the people who come to this country not to work and without a connection who are excluded. My lords, my lady, the State Pension Credit Act is at tab 4 of Volume 1.
No, we saw Section 1.
Yes. 1.2a is in Great Britain. Could I just remind your Lordship of that?
Yeah.
And 1.5 says regulations may make provision for the purposes of this Act as to the circumstances in which a person is to be treated as being or not being in Great Britain. So the regulations tell you who falls into the in Great Britain. If your Lordship turns to tab 10, I appreciate we've looked at this, but I must ask you to look at it again. Persons not in Great Britain is the heading.
Tab 10, did you say?
Oh, it's tab 9, I beg your pardon.
Must be 9,
Oh,
yes.
Yes.
Yes,
Tab 9.
this is a crucial regulation.
You think I would have got that tab right, but never mind. Tab 9. Headed persons not in Great Britain. It's defining the 1.2a. And we've seen that subject to paragraph 2, a person is to be treated as not in Great Britain if he is not habitually resident in the United Kingdom, the Channel Isles, the Isle of Man, or the Republic of Ireland. But for this purpose, no person is to be treated as not habitually resident if he falls into A, B, C, D, or E. So the first point is, people who fall into A, B, C, D, and D are deemed or are treated as being in Great Britain, and they can't be treated as not in Great Britain because they can't be treated as not habitually resident. It's a cumbersome way of doing it, but that's what they've done. And if we start with the people set out in 2.1a, I will draw your Lordship's attention to 2.1b. Had Miss Patmalniece had a favourable decision on her asylum application, she would have had a domestic law right to reside under 2.1b because she would have been a refugee. But the decision went against her. But going back to 2.1a and the range of people in 2.1a, this regulation sets out a broad range of persons, and I'll take you through them in a moment. And those persons are persons who are both economically active, or even if they're not economically active, they have a sufficient degree of social integration to justify them being treated as habitually resident and automatically entitled to meet the 1.2a test. We start with the first line of 2.1a, a worker, for the purposes of Council Regulation 1612/68. And if I could ask your Lordship to look at tab 10, and I do mean tab 10 this time, and I would ask your Lordships and your Ladyship to look at Article 39, because this is where worker starts, and we'll be looking at the regulation in a moment. And 39 says freedom of movement for workers shall be secured within the community. Then it says it entails the abolition of discrimination in relation to particular matters. Then there's the right, subject to limitations. A, to accept offers of employment made. B, to move freely within the territory of member states for this purpose. C, to stay in a member state for the purpose of employment in accordance with national rules. And D, to remain in the territory of a member state after having been employed in that state. So it's people who are coming to work, and indeed it covers work seekers, say for the derogation for Article 8 nationals. It covers those who are working, and it covers those who finish their working life and they would like to stay in the United Kingdom. My Lord, that's workers, and then we start with the regulations that are listed in the English regulations. And we start at tab 14. And 14 at Article 1. If your Lordships have tab 14.
This is Regulation 1612/68.
1612/68.
Yes.
And Article 1 says any national of a member state shall, irrespective of his place of residence, have the right to take up an activity as an employed person and to pursue such an activity within the territory of another member state. So they are, Regulation 2.1a, deemed to be habitually resident, people who have taken up activity as an employed person. Your Lordships may want to look at Article 10 as well, because we'll see that there are rights for the family members too, because Article 10 says the following, irrespective of their nationality, have the right to install themselves with a worker who is a national of one member state and who is employed in the territory of another member state, his spouse, descendants under the age of 21 or dependents, and then dependents who are dependent relatives in the ascending line of the worker and his or her spouse. So that's the first one. Workers and their family members are covered. Secondly, we look at tab 15. That's the next one referred to in 2.1a. And if you look at tab 15, you'll have Regulation 1251/70. And you'll see from the second recital, on the first page, the reference that I've just shown you to 48.3d, the right to stay in this country after you stop working there. And if your Lordships go to Article 1, it says this regulation applies to nationals who've worked as employed persons in another member state and to members of their family, as defined in Article 10. And then Article 2 gives those people the right to remain permanently, not now economically active people, but people who have ceased to be economically active. And these are a worker who at the time of termination of his activity had reached the age laid down for entitlement to an old age pension. So provided you've lived there, been employed there for 12 months and lived there for more than 3 years, there are always conditions. But it's people who've worked here, have sufficient integration because they've worked here for at least 12 months and been continuously resident. And 2.1b is a worker who, having resided continuously in the territory of that state for more than 2 years, ceases to work there as an employed person as a result of permanent incapacity to work. So those are two groups of people who are not economically active, but they have sufficient integration to justify being brought within the automatic group of people habitually resident. And your Lordship will see Article 3. the members of a worker's family referred to in Article 1 who are residing with him in the territory shall be entitled to remain there permanently if the worker has required the right to remain. So you can stay with your husband or your wife, and not only that, if he dies, you can stay there, because even after death, so the widowed are also covered. So the socially integrated group of people covered by this are the retired and permanently incapacitated worker, his or her family members, and his or her widow or widower.
Yeah, so that's the first two. And then we go to...
Then we go
directives.
to 68360, which is tab 22. And this is a directive that makes it absolutely clear that there is the right to reside, on top of what we've just said, because we've talked about the right to take up activity as an employed person and the right to install yourself. And I'm sure there will be British law saying install does not mean reside. But lest there be any doubt about that, we have 68360. And Article 1 says member states shall, acting as provided in this directive, abolish restrictions on the movement and residence of nationals of the said states and of members of their families to whom Regulation 1612/68 applies. Member states, Article 2, shall grant the nationals referred to the right to leave their territory. And then Article 4, member states should grant the right of residence in their territory to the persons referred to in Article 1 who can produce the necessary documentations, and then there's assistance for getting residence permits. So that's at the moment workers, retired workers, permanently incapacitated workers, family members, widows and widows of the deceased. Then we have tab 23, which is Directive 73148. Which is the last one specifically referred to in 21A. And this deals with abolition of movement and residence within the community for nationals with regard to establishment, people who aren't employees, but they're self-employed. And Article 1 says the member states shall, acting as provided in this directive, abolish restrictions on the movement and residence of nationals who are established or wish to establish themselves in another member state, nationals of a member state wishing to receive services, the spouse and children, and the relatives in the ascending line. And you will note from Article 4.1, fourth paragraph down, that you can't remove a residence permit from a national referred to in 11A, the self-employed, on the grounds that he's no longer in employment because he's temporarily incapable of work as a result of illness or accident. So there we have the temporarily incapacitated self-employed person.
Now, are you going on to look at the other grouping? It might be better to do that after.
Yes, I'll do that
short
after lunch. Well, so far I simply dealt with the range of people, and you can see where I'm coming from. Under 2A, it's not workers, it's a whole range of workers,
Yes.
self-employed and or incapacitated, retired and or family members. Some of the family members actually come under 2.2, but it doesn't actually make any difference for present purposes. The range of people is core.
Well, we look forward to seeing you at 2 o'clock.